We often hear employees complain that their employer made up a reason to terminate them. It's pretty common in the workplace because often the employee feels like they've done everything right, they performed well, and then all of a sudden they're fired and they don't believe that the reason their employer gave is true or accurate. Employees are often shocked and they are in a state of disbelief when they are terminated, and they feel that the employer is actually lying about the grounds for termination. They feel that it's false and unsubstantiated, and so they're truly just trying to figure out what just happened because they were fired and the reasons just don't make sense. I was drawn to employment law because I worked in a hostile work environment, so I knew what it felt like to endure unsafe working conditions. And I really wanted to advocate and help employees that I understood. And I think it's important to provide a voice to these employees because I didn't have a voice for so long. I knew that employees need a voice. They need someone to say, hey, what you're doing to me is wrong, and I'm going to hold you accountable. And that's what we do. We tell stories and we hold employers accountable when they violated the law. In California, employment is at will, so an employer has a right to terminate an employee as long as it doesn't violate a law, like discrimination laws or retaliation laws or some public policy. And so if an employee feels like they've been fired unjustly, then they're looking at the reason why. Was it related to discrimination or retaliation, or did it violate some public policy? Because if it did, then it might be illegal in California. California is an at-will state, meaning an employer can terminate an employee. Their employment is at will. However, an employer cannot simply terminate an employee if their reasons for termination are motivated by discrimination, retaliation. Employees are still protected under the law. That's why it's really important to consult with an employment law attorney to assess the facts and what transpired right before that termination so we can see if it was illegal. Terminations in at-will states that are still illegal would be terminating an employee because of their protected characteristic like race, national origin, pregnancy, medical condition, disability, or retaliating against an employee just after they made a complaint or opposed some illegal conduct like harassment, unlawful wage payments, wage theft, unsafe working conditions. Maybe they just disclosed a pregnancy or that they feel like they're being sexually harassed in the workplace. If an employer terminates an employee for discussing that, disclosing it, or opposing it, that could be a wrongful termination, which overcomes that at-will status in California. Employees may feel that the reason for termination is unfair or wrong. But if the employer is actually making up a reason, creating this pretext, simply an excuse to terminate an employee, that may be where, once we look at the facts and the violations of law, it might be an actionable wrongful termination case. So unfair and illegal, there is a difference. So oftentimes employees think the termination was simply unfair. But if it's made up, if it's simply an excuse to cover up retaliatory or discriminatory motives, then it could be actionable under the law. For a wrongful termination case, pretext is an excuse. It's an employer's excuse to terminate the employee, and we really look at what that reason is and that excuse, because if it is pretext, it means that they're likely just covering up their discriminatory or retaliatory motives. Employers are usually looking to cover their tracks. So when they give a reason for termination, they want it to be justified. They want a business decision to justify the termination. So they want to avoid liability. So if they are making an excuse or trying to come up with a justification for termination, it's because they're covering their own tracks. I have seen stellar employees wrongfully terminated more often than most people would imagine or think. Good employees can get terminated for unlawful reasons, and that's why it's really important to look at the facts and what transpired leading up to that termination to see if it's potentially illegal. If an employee says, maybe I'm wrong, maybe it really was my fault when they've been fired, I think that's okay. They should assess the situation, but they should also make sure that they're not just giving up and giving in to the employer's reasons, especially if they don't sound right. If the employer's reasons for termination sound off, unjustified, then they should seek legal advice, because if there's an ulterior motive, if there's discrimination or retaliation involved, then the employee really does need to seek advice to make sure that they're exhausting all their efforts to see if they potentially have a claim. If an employee suspects that the reason they were fired is not the real reason, they should gather their documentation, look for their performance reviews, or request it from the employer. They have a right to request their personnel file and payroll records, and we want to look at performance evaluations, emails, accolades, awards, anything to substantiate that the employee was performing well and that the reason for termination is just not justified. It's not supported by the documentation that proves this employee was a great employee. After an employee is terminated and they feel like the termination is wrongful and not justified, they should absolutely not sign a severance agreement until they consult with an employment law attorney so they understand what rights they're waiving or releasing if they sign that severance agreement. If an employee has been terminated, they should act fastly. It's very important to understand your rights and the statute of limitations associated with your various claims. All claims have different statute of limitations, but they could be as short as 1 year or as extended to 3 or 4 years. So it's important to talk to a professional like an employment law attorney to make sure you're well within those statute of limitations if you feel like you've been wrongfully terminated in California. Evidence that a court or investigator will look into when an employee is saying, hey, wait a minute, this termination is not justified, could include performance evaluations, emails, text messages, anything to show that the employee was performing well, was being praised, was receiving accolades, awards, was meeting all standards, and then all of a sudden they're terminated for this pretext reason, something that's not justified, doesn't make sense, sounds like an excuse. All of that paper trail that supports that the employee was actually a great or stellar employee will help support the employee's claim that this simply is not true and that the employee is creating a false reason for termination. Once an employee comes to our office for an initial consultation, it looks like a meeting. So we start out with a meeting, we talk to the employee, we want to understand the facts, the story. Once we get the information and review the documentation, we then pair the employee by showing them what potential claims they may have to pursue against the employer. And we want the employee to understand what that looks like, what litigation looks like, what the process looks like. It's definitely a process. We have to take lots of little baby steps to get to the end game. And so we sit with the employee, discuss that process, and let them know what the next year is going to look like if they choose to move forward with these claims. A win for an employee in a case for wrongful termination, discrimination, retaliation, it's not always about money. It's about telling your story, putting a voice to the story, holding the employer accountable, and then if there is a settlement or a win at the end of that journey, that's just icing on the cake. Because really what you want to do is say, hey, what you did to me was wrong, and I'm not going to go away silently. I'm going to put a voice to the story. And to me, that's powerful enough. The ideal person to reach out to our office is someone who feels like they've been terminated wrongfully, that they've been subjected to some type of discrimination or retaliation. They were targeted, singled out, treated unfairly, harassed. That's the type of person we want to help. That person that's just recently was fired right after they reported a medical condition, a workplace injury, unsafe working conditions, a need for leave to recuperate from a serious medical condition, and now they're fired. They have no place to go. They are feeling hopeless and lost, and they're worried about how they're going to feed their family. Those are the people that we want to help and at least explore whether or not they have potential claims against the employer. The one thing that I want someone to walk away knowing is that you do have employee rights. Yes, California is an at-will state, but that doesn't eliminate all of your rights in the workplace. You have a right to a work environment that's safe and healthful and free of discrimination and harassment. So explore those rights. Don't just give up. If you have a story to tell your story.